Good afternoon. How's everyone doing? That's great. Glad you all came out. Definitely appreciate it. Also like to give a thanks again to the LA Law Library and Ryan for this great collaboration. Our goal is to provide great content to you guys and distill a lot of technical information in layman's terms so that it's easy to use and understand. As you look at the slides that you'll have before you today, any of the ones that you see where the title is not in black like this one, but is in red, that means that more information and details on that topic are on your USB drive. If you have not received a USB drive, before you leave today, we'll provide you one. And as he said, my practice focuses on internet law and intellectual property issues. Now I'm going to give you guys a disclaimer before we get started. This presentation is rated R, for real. It's not rated PG for playing any games. We're here to get down to business and, make things happen. So in 1992, I woke up, I think it was a Saturday morning, aboard the USS Racine naval vessel, 500 feet long in the middle of the ocean, Pacific Ocean. And I crawled from my bunk all the way to the top deck, and I looked around. I looked to my left, I looked to my right, walked all around, saw the various crew members working. And what I realized is despite the vastness of the ship that I was on, I couldn't see, we were in the middle of the ocean and I saw no shoreline in sight. I didn't see the California coastline, I saw nothing. And the ship was anchored. However, we continued to slightly move, slightly toss and turn back and forth in the middle of the ocean. The reason that this is important and I bring this to your attention is because the internet is just like the ocean. It's always in motion. It's always something going on. Think about Facebook. Think about LinkedIn, Twitter, Instagram, Yelp. Someone's always posting comments, posting pictures, posting videos, blogs, wanting to show something. And that's exactly why we have to understand how we can contain it and also understand how the government, both state and at the federal level, intersects with our use of the internet, whether you're a legal practitioner or your clients have a business there or what have you. Now, I'm going to give you a definition of social media. It's any tool or service that uses the internet to facilitate conversations. Any website with a commenting community, and it's created for fast, instantaneous, not memorable conversations. Because as we know, most people view the internet as, oh, I'm just making a slide remark, kind of like a text message or something. But as we know, the little remarks and little comments and posts that you make can come back to haunt you. Any attorney can tell you all about the law. And you tell them what your situation is, and they can point out all the flaws, all the potential legal issues, what you might expect, what might happen, what might not happen. That's called taking the bar exam. What I try to do is focus on helping my clients and helping other attorneys not only identify legal issues, but overcome them, avoid them, increase their revenue, and reduce their exposure to liabilities. As you can see, hope is not a strategy. You have to be vigilant about your reputation and your online presence, because if you don't, everything that you've established, everything that you've built up over the years will soon become history, and no one will know about you, and your competitors may overtake you. So let's get down to it. Companies of all sizes, small business owners, large corporations, it is very advisable to have a social media policy. Now, you think a social media policy, obviously there's certain things you don't want said, and there's certain things you want said. Now, the best policy, the ultimate policy would be no to everything, right? No Facebook, no YouTube by the employees. That way I can monitor everything. That would be maximum security. And we know that people that have maximum security are in prison. That's not what we want. We want to find that common ground where we can protect the content, safeguard what we're doing, and also do it in an effective, organized manner so that we make sure we properly advertise our businesses and accomplish our goal. Now, anyone that knows U.S. Airways knows that they've learned that social media policies are very important. I don't know if anyone in here is familiar with the incident that they had in mid-April of this year where a customer complained on their Twitter account. And in response to that Twitter account, they inadvertently attached a pornographic image of a lady, and it was a horrible depiction of a woman. But it was tweeted to hundreds of thousands of followers. So they recognized it, they apologized, and they got it removed. But nevertheless, look at all the damage that was done. So when you're considering creating a social media policy, first start off with, these are some of the small steps that you want to consider. What are the key reasons that your company is online? Do you empower your people to use social media correctly? What are ways that you're going to educate the employees on the law and continue to educate them on the changes to the law? Because this is a very evolving area. And last but not least, definitely not least, especially with U.S. Airways, are there ways to monitor what's going on online? So you say, okay, well, I think my employees have common sense. I know everyone here, we have a small organization, or the people that are doing our blogging, they're not going to post anything too outrageous or outlandish, so are we good to go? Well, no, it's not actually time to spike the ball just yet. Do you have a well-delineated policy of who owns your company's social media account? Northern District of California Federal Court, a situation arose between PhoneDog and Noah Kravitz. Mr. Kravitz was their video blogger. He handled their Twitter account. He built that account with the followers up to 17,000 followers. He resigned and took the followers with him. I believe it was PhoneDog_Noah. Well, the company figured, hey, we own PhoneDog. They're our followers, so they belong to us. However, it wasn't that simple. They actually went to court. PhoneDog sued Mr. Kravitz for the followers to be returned to them, and they sued for $2.50 per follower per month. Nevertheless, the case settled and Noah was able to keep the followers. And this was all because they didn't have in their policy who owned the social media accounts. Now, I phrased this to Alphabet Boys to make it easy for everyone to remember. You have the Food and Drug Administration, the Federal Trade Commission, the Federal Bureau of Investigation, and the Federal Communications Commission. The government is extremely concerned with businesses of all size concerning what you do in social media. And the reason being is that most consumers trust and read and believe what they read online. In addition, the majority of consumers trust peer recommendations. Has anyone ever heard the term, someone says, follow me on Facebook? Anybody heard about that? Follow me on Facebook? Well, believe it or not, the FDA follows people on Facebook, and you didn't even have to invite them to. They don't mind. There was a company called IPSA, it's still around here in Thousand Oaks, California, and just this year in February, the FDA told IPSA that their advertisement on Facebook was false and misleading. They showed their logo, which you see right here, and they had a statement. The statement said this: if you've just been diagnosed with hypothyroidism or are having difficulty controlling your levothyroxine blood levels, talk to your doctor about Tirosint. Well, what was the problem with that? There was no mention of the possible side effects. So the FDA said your failure to mention that the serious and frequent occurring risk is misleading to the public and suggesting that the medicine is safer than has been demonstrated. Also, they did not mention that the drug is not the right choice for the illness. It's not always the right choice for every illness. Now, before we talked about someone posting a comment, you can't get in trouble for liking a comment, can you? Well, the Food and Drug Administration feels differently about that. Because think about it, if you have a business, you're putting out a good product or service, and someone says something positive about you, why wouldn't you want to just hit the like button and share it with other people? Well, that's what A-Mark Enterprises did. A-Mark Enterprises is a dietary supplement maker, and they received the first ever enforcement action based on social media for liking a consumer testimonial about one of their products. On March 10th, 2011, on A-Mark's Facebook page for PolyMVA, right here, someone wrote, "The product has done wonders for me. I take it intravenously 2 times a week, and it has helped me tremendously. It enabled me to keep cancer at bay without the use of chemo and radiation. Thank you." And in response, A-Mark hit the like button. I think most of us would just go ahead and hit the like button. You say something so grandiose about us. Well, the FDA said by liking the post, the company made an impermissible drug claim that the product at issue was intended for use in diagnosis, cure, mitigation, treatment, or prevention of a disease. Also, the FDA said your products are not generally recognized as safe and effective for the above referenced conditions and therefore are new drugs, the marketing of which must be pre-approved by the FDA. In addition, the FDA stated the products are offered for conditions that are not amenable to self-diagnosis and treatment by individuals who are not medical practitioners, making them misbranded under the FDA. So this was just an example of the FDA getting involved, but the Federal Trade Commission and other agencies also have rules on their advertising. So it's very important that you pay close attention to their rules, because the same rules that they have if you have a brick and mortar store, we're learning apply online also. Business endorsements. Now, who wouldn't like it if you could have LeBron James stand in front of your business or Kobe Bryant and say, this is a great company, and have your product or your business card or your shirt, your company's logo on the shirt in front of him and just smiling for the camera all day. Well, let's first of all talk about what an endorsement. An endorsement is any advertising message that consumers are likely to believe reflects the opinions, beliefs, findings, or experiences of a party other than the sponsoring brand, even if the views expressed are identical to those of the sponsoring brand. The person endorsing the brand must have been a bona fide user of the product or service at the time the endorsement was made. Endorsements must reflect the honest opinion and experience of the endorsers and disclose any material connection with the brand they are writing about. Material connection. Are you giving out a free t-shirt? Are you paying the people? Are you giving them a free use of your services, some free products in exchange for endorsing it? Then that has to be disclosed. Let's talk about this in action. The Federal Trade Commission and Cole Haan, just this year, March 20 of 2014, participants got a shot at winning a $1,000 Cole Haan gift card if they created their own My Wandering Soul boards on Pinterest and used them to repin 5 of their favorite images of Cole Haan shoes with the hashtag Wandering Soul. The FTC said the Pinterest boards created through the contest were endorsements of Cole Haan products, and the fact that the pins were incentivized by the opportunity to win a $1,000 shopping spree would not reasonably be expected by customers who saw the pins. To the average users, Pinterest boards might have looked like normal, uniquely inspired content rather than part of a marketing campaign. The FTC decided against taking any enforcement action against Cole Haan on the condition that Cole Haan go back and tell its Pinterest users to label the post as part of the contest, and that they go back and double check that they did all of the labeling. So, I mean, it seems simple, right? An opportunity to win a $1,000 gift card, who would think it would get you in trouble and run you afoul of the FTC that fast? But it's happening. And as you can see, March 20th, 2014, this is going on now. Let's talk about some of the tools that are at your disposal if you have been the victim of cybercrime, cyber attacks, or any other type of frauds or schemes. We have the FBI Internet Crime Complaint Center. And also, I'll add that here in Los Angeles, LAPD has the Computer Crimes Unit that actively investigates cyber crimes. But as you can see from the definition, these are some of the things that they're set up to monitor, take a look at. There's a very detailed information package from their 2013 report that's attached on your USB drive that goes over, a lot of the pertinent scams and other things that they investigate. But I will tell you that as of 2013, the highest number of complaints in the entire country came from California citizens. And that was in 2013, and these are growing every year. So I strongly encourage you to be vigilant. So let's talk about 2 of the most popular scams that are going on right now. One is called ransomware. Is anyone familiar with ransomware? Ransomware is a situation where you open up an email or you click a link in an email, and all of a sudden a message pops up on your screen. It encrypts all of the files on your computer, and it says, send this monetary payment to this address or this location, and a pop-up countdown timer is on your computer. And you have to do it within a certain period of time, and if you don't, you'll permanently lose those files. This is happening all the time. I had a client that just called me yesterday dealing with this exact issue. And this is something that the FBI can investigate for you. However, if strangely enough, it does not fall under LAPD Computer Crimes Unit, you would actually report it as extortion to your local station. The second issue that LAPD is seeing more on the rise is social engineering issues, where people are disguising themselves and contacting you saying, hey, I'm with your internet service provider, or I'm in the tech support department and we have some issues. Can you please go to your computer and make a few keystrokes of a different password or a few other numbers or something to that effect, and they also sabotage and take over your computer. So that's just something to be on the watch for. The Telephone Consumer Protection Act. The Federal Communication Commission requires prior written and unambiguous consent by any person receiving calls from an automated telephone dialing system. The law is expanding the definition of calls to now include text messages and other messages that we so actively use nowadays. Now, if you want to avoid liability, these are some of the things when we're talking about the prior written and unambiguous consent. These are some of the main items that must be contained in that. You have to identify the company to whom consent is being provided. You have to include the consumer's cell phone number, obtain an affirmative written agreement, clearly and conspicuously disclose that the consumer is authorizing the seller to engage in telemarketing and mobile marketing, and that the calls may be made with an automated telephone dialing system. Disclose that the consumer is not required to provide consent as a condition of purchasing the goods or services. And lastly, the consumer may revoke his or her authorization to receive further calls or messages at any time. And the revocation does not have to be in writing. Privacy. Everybody is concerned about their privacy online, as we rightly should be concerned about our privacy online, because that's the purpose of, we wouldn't set up a password if we wanted everyone to read the things that we have on there, especially our medical records and things of that nature. Well, we have federal law and we have state law. So far, it's been showing lately that the trend has been the Federal Trade Commission on the federal level has been the active enforcer of privacy. In 2012, they charged the operator of a website and a mobile app with collecting personal information from a user's mobile device contacts list without the user's knowledge or consent. In addition, they charged an online market research company with violating its own privacy policy by collecting personal information such as usernames, passwords, financial account numbers, social security numbers, and credit card numbers. But back to California. In California, we have the California Online Privacy Protection Act. In a nutshell, if you operate a commercial website and you obtain any of the following information, you must have a conspicuously posted privacy policy. So this applies to you if you have a website or if your clients have a website and they ask for just the first and last name, someone's address, someone's email address, someone's telephone number, social security number, or other identifier that permits physical or online contacting of a specific person, then this applies to you. Now, as you can see, the Do Not Track Amendment went into effect this year. The Do Not Track Amendment provided that businesses now have to disclose how they respond to do not track signals or other mechanisms used by consumers to prevent the surreptitious collection of their browsing history. If a company can access your browsing history, they likely know the types of things you like to buy, the types of places you like to go, so they can cater their marketing campaign to them. And so consumers are being more vigilant about that, installing devices on their computer to protect themselves. So now companies, in response to that, have to let them know that they're complying with it. Second, effective January 1st, 2015, the privacy rights for California minors in a Digital World Amendment will be in effect. This is also known as the Eraser Law. What the Eraser Law says is that for minors, they have to be given the ability to remove their own information that they post online. We know that minors are naive, and oftentimes in the fit of passion or rage or just the heat of the moment, they might post something online. And we don't want that to detrimentally affect them for the rest of their lives. So they have the opportunity to remove certain things. And there are exceptions and restrictions that go along with that we can discuss if anyone has any further questions on that. Now, you would think that the average person that has a mid-level company wouldn't be up to speed maybe necessarily on all the different privacy rights and different laws that come out. However, you would be more likely to think that a large corporation or a large company would be following these, especially a company that had their own in-house counsel, that actively hired attorneys to help them with various issues. Well, that's not always the case. Facebook couldn't keep a secret. In 2012, Facebook agreed to 20 years of privacy audits after the Federal Trade Commission said the firm deceived customers by publicly sharing information that they had promised would remain private. Some examples are they made friends lists public without consent. In addition, they claimed that the users that deactivated or deleted their accounts would have the photos and videos removed, but people were able to still retrieve those same photos and videos. So we talked about privacy as it typically pertains to everyone, but now we also have special privacy rights that pertain to children, the Children's Online Privacy Protection Act. Does your online service reach a general audience and you know you get information from children under 13? Let's think about that question. Okay, what is an online service? An online service includes mobile applications, gaming platforms, plugins, advertising networks, location-based services, voice over internet protocol. I know a lot of children nowadays that are in kindergarten that are running around with cell phones, and they know how to get online, they know how to download apps, they know how to go on YouTube, they know how to log in and hit the enable the location button saying this is where I'm at. And if you think about it, think about Yelp. You put in your location, find out what stores are around, what stores are still open, what restaurants are by you. A lot of people use Google Maps for directions. Not too many people are carrying Thomas guides around still. But, so this could really apply to you a lot quicker than what you think. Especially, I talk to a lot of my programmers that I work with that are mobile app developers and, advise them on some of these things because they easily could run afoul of this. But nevertheless, if this does apply to you, you have to post a privacy policy that complies with the law. You have to notify the parents directly before collecting personal data from children. You have to get the parents' verifiable consent before collecting information from kids. And you have to honor the parents' ongoing rights. So if they change their mind and say, hey, well, you know what, I no longer consent to this, then it has to stop. And finally, you have to implement reasonable procedures to protect security of children's personal information. What's reasonable? A lot of times we have to look into, you'll say something?
Who's the enforcement arm for this?
I think the FTC, they've been doing most of the enforcement with the privacy. Yeah, and the thing is, a lot of times when they create these acts, they don't necessarily have the various lines or words that I have underlined completely spelled out as to how you're going to do it. And so, it's all up to judgment. But what they have said in some of their enforcement actions is to look at their past enforcement actions and look at the content, so use that as a guide going forward until the law, makes its way through the court. But it's very tricky. So let's talk about the fact that here you go, you're online, you collect customers' information, and you're building up your business or you have an established business, and unfortunately there's a data breach. We know that this is happening more and more every day. Everyone knows about Target. We know about all the various banks, things of that nature. California is on the forefront of data breach law and enacted the California Data Breach Notification Law on January the 1st of this year. And what the law said is effective that you must disclose a breach of a username or email address in combination with a password or security question and answer that will permit access to an online account. The reason this is so important is because now other states often model their laws often off of California, and you will likely see this modified and going through various changes over the years throughout the country. So this is extremely important. On your USB drive, I included an article from last week, October the 2nd, in the Los Angeles Times, where Cedars-Sinai had a data breach. And originally, I think they were saying it might be around 500 individuals that were affected, and now it's up to 33,000 people that were affected by this data breach. So this can happen because, and the reason that this is so important, because no matter what kind of safeguards, no matter what kind of controls, you can buy Norton, antivirus, you can buy all these things, but at the end of the day, it's the human factor we can't control. Because anyone that has permission from the company can go post any time of the day, can log in, or they could leave their computer and walk away in a coffee shop or something like that, and someone can go online and disrupt things. Controlling the Assault of Non-Solicited Pornography and Marketing Act, CAN-SPAM. No fraudulent, abusive, or deceptive commercial email. I know that we have some lawyers here, and oftentimes I know people are familiar with the one bite rule as applies to dogs. You know, a dog gets one chance to bite you sometimes, and before they label it vicious. Well, they came up with a one bite rule for this. So you can send an unsolicited commercial email message properly labeled to a consumer with easy means for a consumer to opt out, but if they opt out, don't send it again. Well, who has run afoul of this issue? Kodak. Everybody, is Kodak still around? They're around in some form or fashion.
Yeah.
Well, they didn't offer an opt-out method for consumers. And they said, you know, hey, it was an accident, we're sorry, you know, please forgive us, get a do-over, something like that. And the government said, okay, and for your mistake, it's $32,000 for that. So we forgive you, just pay $32,000. Also, Value Click Media, they were a little bit more egregious with their what they did. They used deceptive emails, banner ads, and pop-ups to get customers claiming that they were eligible for free gifts. They ended up paying $2.9 million for their behavior. Anybody that is on social media, whether you're using Facebook, LinkedIn, Twitter, Instagram, you know that it's all about content and content optimization and always putting something new out there that gets people's attention. You know, I always want to post. You always want to, you know, put a thought-provoking statement up there, a quote, something like that. Well, one common question that I get is, why can't I use some pictures I found on the internet? Because I like the picture, it's already up here, it's free, I don't have to pay a photographer, let me just go ahead and post it. Well, you can't because of copyright protection. And in a nutshell, copyright law protects original works of authorship, including photographs, videos, blog posts, and other things that are posted on Facebook, Pinterest, YouTube. And as a general rule, a person who creates an original work of authorship owns the copyright for the work. And if you share it without their permission, or if it's not fair use, that constitutes copyright infringement. There's some more details about copyright, but down here I want to draw your attention to DMC takedown notices. It's at the very bottom, the last bullet point. DMC stands for the Digital Millennium Copyright Act. The takedown notice is a notice that you would send to an internet service provider if you notice that, for example, your photograph or some of your other copyrighted material is on someone else's website and they did not request your permission. You send that in, and there's certain language that has to be put into the letter, and therefore, you know, put someone notice that you would like it removed. You have to show proof that you own the copyright and things of that nature. Then they give the person that posted it an opportunity to rebut it. It can go back and forth. It can end up in court. But the majority of the time, if a person knows they took it without permission, they don't want to risk going to court, and they just go ahead and remove it. Some companies have to send these notices out every day to people that are stealing their content and posting it. So copyright infringement and money. When you sue for copyright infringement, you can sue for actual damages or statutory damages. Now, according to the law, statutory damages range from $750 to $30,000 for each work that's infringed. However, if it's done willfully, $150,000 for each work that's infringed. But if you read a lot of the cases, especially ones here out of Central District, which is our federal court not far from here, oftentimes, although the statutory penalties provide for this, they're very critical before they just go off and award a $30,000 per work infringed. So they want to see proof that it was really valuable, They want to see proof that you have an established reputation. So it's not a given. People always sue for the max, but it's not a given that you're going to get the max. So it really depends also. Also, you see here under willful, I have Cleveland Bar. So we're talking about, and this goes right along with what you were saying, how likely is it for people to go after someone for infringing, right? You know, what's too minor, what's too major, you know. So another thing that's covered under copyright law is obviously recordings, sound recordings, songs, things of that nature. Has anyone here ever been to a bar or a restaurant where they play music, maybe like they have a little band set up and they play maybe Michael Jackson songs or the 60s music, things of that nature? Those are called cover songs. So Broadcast Music Incorporated, BMI, and ASCAP, they send people every now and then to different establishments and listen to see if any of these cover songs are being played, especially popular ones. And they see if a license was purchased in advance. Well, if a license wasn't purchased in advance, then that's copyright infringement because they don't have the right, not even playing them. I mean, I'll leave it at that, but they don't have a right to play it. And there was a bar in Cleveland. I have a verified complaint. This was from, let's see here, March 2014, where they played 10 songs. Cover band came in and played 10 songs. They sued the bar, what is it called, 69 Taps Medina in Cleveland, Ohio, for $1.5 million. They said it was willful infringement. Now, they're just a bar playing music, right? You would think, is anyone really concerned about it? Who would think someone would wander in and pay that close attention? But it's happening. So, you never know. But that's just to give you an example of something that's happened this year and the way things are going. Now, we talked about getting permission, which is the easiest way to try to avoid copyright infringement. However, if you don't get permission, there's a judicial doctrine called fair use, where it is fair to use a certain portion of content, for example, for criticism, things like you see on the news, and comment like you see on the news. Also, parody, like on Saturday Night Live, where they use different things and make fun of things. Teaching, like what we're doing today, scholarship, and research. One of the things that you'll see overwhelmingly, depending upon the brand name and what's at stake, a lot of times the lawsuit's amount arises over the amount that was copied and the money that was made. So if they see that you've made a lot of money, you're definitely going to be on their radar. But if you didn't really make too much and the brand is not that concerned with you, it really depends. But the bottom line, the best practice is to get a fair use opinion before, so you know exactly where you stand and have a good idea. And the ultimate best solution is to get permission in advance. The Internet Order Merchandise Rule. When you advertise merchandise, you must have a reasonable basis for saying or implying you can ship it in a certain amount of time. If you don't guarantee a time plan, then 30 days is reasonable. If you can't meet that deadline and the customer doesn't excuse your non-performance, then you have to promptly refund all of the money to the customer. Now, I put this on here so everyone can see this is how easy all the customer has to do to go to the FTC's website and scroll through this little FTC complaint assistant to make it real easy to file a complaint against someone that has violated this rule or any of the other FTC rules that we've talked about today. Something that's very important to understand about the Internet Order Merchandise Rule is that the time to deliver the product or service starts running when you get a properly completed order. It doesn't matter whether or not you've received a check or the money has cleared the bank. The clock already starts running. In addition, if you violate the rule, you can be sued by the FTC for injunctive relief and fined up to $16,000 per violation. So now we're going more so into invasion of personal privacy. A lot of us know this as revenge porn. And revenge porn here in California is a criminal offense. It's a misdemeanor to take and circulate without consent images online with the intent to harass or annoy. And images that we're typically talking about with revenge porn are intimate pictures that a husband and wife or boyfriend and girlfriend shared amongst each other while they were together. There was, we're going to talk about another case, but there was a case, I don't know if any of you are familiar with it, a guy named Kevin Bollard, and he was down in San Diego. And what he did, I think it was last year or the year before, he went and set up a website where you could post the pictures of people. So like a guy would post a picture of his ex-girlfriend, or a girl would post a picture of an ex-boyfriend on there, and then he would charge them to post the picture, widely disseminated, and then he set up another website where the people whose pictures were posted could pay him another $350 to have the pictures removed. Well, he was obviously arrested. He made hundreds of thousands of dollars. Now he's so sorry for all of his behavior and things of that nature. But it does happen. The punishment for the first violation is up to 6 months in jail and a $1,000 fine. And also, they can suspend your driver's license. Yeah, I saw that the other day, so let me add that on here. And previously, the law protected pictures taken without permission. But now the law protects pictures that were taken with permission, but were expected to remain private. Invasion of privacy again. Distribution of sexually explicit materials. I redacted the name and just put victim with Jonathan Bruce and Renelia Rodil. This was up in Santa Clara Superior Court. Jonathan was dating the victim. They were boyfriend and girlfriend. In the course of their relationship, they exchanged intimate photos. So Jonathan had very intimate photos of the victim. Well, after they broke up and he began a relationship with Renelia Rodil, he shared the pictures with her and gave them to her. So what Renelia did was she decided to go ahead and set up a Facebook page, a fake Facebook page under the name of the victim, and began to post all of these pictures, these intimate pictures of her, and began to invite her relatives, friends, and co-workers to friend her page. Well, obviously, they ended up in court, and this was the first case ever based on this, that a civil case where they got a $250,000 verdict for the plaintiff in this case. And part of that was $60,000 in punitive fees for just engaging in such a harm like that. So, this stuff is happening. This just happened in February 2014. And because of this, the law is being amended and is going to go into effect in July 1st, 2015. So now, like when this case went through, the victim's name was on the complaint, but now going forward, you'll be able to use a pseudonym, and there's other issues that are going to allow. But yeah, this stuff is happening all the time. And basically, as you can see, since this slide title is highlighted in red, some more information is included on your flash drive about this. Defamation. There are a lot of reputation arsonists out here on the internet. It's happening all the time on Yelp. I've had numerous clients this year contact me and say, hey, they got a call from someone where they posted a negative comment just to kind of disparage the business for no good reason, and that if they want it removed, they have to pay them some money to remove it. Sometimes they have evidence, sometimes it's just an oral statement, but it's happening. And it's kind of a toss-up to get the Yelp or some of these other websites to remove the data, because they don't have to based on the Communication Decency Act. So it can be a very intriguing process. Some of the options that you have are to ignore it. Some people pay SEO, search engine optimization companies, to try to suppress the comment, or you can hire an attorney. An attorney has various options that they can go through to help the comment essentially become de-indexed. But the truth of the matter is the comment will always be on the internet. But once it's de-indexed, it kind of highly reduces the likelihood that anyone will be able to find it, unless they know the identical URL to find that exact comment. So here, defamation, if you publish something, it's false, defamatory, unprivileged, and has a natural tendency to injure or that causes special damage. There was a case here where a lady named Theriot sued the Rap.com, and that's a company here in Hollywood. And this happened in April 2014 because they said she stole film footage and equipment, filmed in Mexico without authorization, and fled Mexico in violation of government order. The reason that I included this on your flash drive is because oftentimes a lot of these cases, fall victim to anti-SLAPP motions, so they never succeed, whereas this one was able to go forward, but it's rare. Because, we have the First Amendment, right to free speech, the right to talk about things you want to talk about, things of that nature. And while we're on that, let's talk about, this is a little off the topic, but let's talk about the case that's going before the Supreme Court. Is everybody familiar with that? The Facebook case? A guy named Anthony Alanis. And so Anthony was married to a lady, and he began making all of these threats on Facebook about he was going to harm her, about what would it be like if I cut you, if I stabbed you, if I did this, if I did that. So he got to talking real off the wall comments. I mean, real violent things he would do to her, beat her up. And so then an FBI agent looked at it and came to his house and said, hey, what's going on? I'm investigating this. So in response to that, he posted some comments about the FBI agent. And he said, I'll cut your throat and give your jugular to your partner and this and that. And so after all of that, they went ahead and arrested him. But the issue is, what constitutes a threat on Facebook? So that's a case that the Supreme Court should be hearing shortly in this term, and they'll give us a clearer definition. Because his argument was, well, just because I said this, there's no clear indication I could really carry this out. How do you know you're infringing my free speech? And in a lot of the posts that he put up, where he made all of these comments, he attached links to rap songs and said, hey, they make these same lyrics in rap songs, and it's okay, so I'm just doing that. I'm just, expressing myself, this and that. But that's something that, be on the lookout for, and that will give us better clarification. But in California, as of now, they are prosecuting people for terrorist threats. So regardless of that, until it comes down, still advise your clients to, be very careful with making threats and making comments, because they even launch investigations based on things that they think might be a threat, especially in the age that we live now, where we can't be so careful as to what might happen. The Computer Fraud and Abuse Act. This is a great tool that you can use for your client or for your company if you have an issue. It allows companies to go after people that steal their data, destroy their computers, interfere with their computer systems. And it's a federal act, so it allows you into federal court. The way the law reads is that whoever intentionally accesses a computer without authorization or exceeds authorized access and thereby obtains information from any protected computer commits a crime. There's a 2-year statute of limitation, and damage must be to data permanently. And damage means any impairment to the integrity or availability of the data, a program, or a system of information. Why? Hackers go after credit card information, personally identifiable information, trade secrets, and threaten to destroy them, just like we talked about ransomware. In addition, the thing is, you have to have evidence and be able to identify the perpetrator in order to go to court. And these are some of the devices that it applies to: iPad, iPhone, the Galaxy, all of those things. But what I want to draw your attention to is the key issue in a lot of these cases is unauthorized access or exceeds authorization. We talked about the Cedars-Sinai article, which was pretty clear, but what exactly is unauthorized access? Unauthorized access would be a situation where, like for example, this Christopher Phillips, he was a student at University of Texas in Austin, hacked into the school computers, got social security numbers, and he was getting 6 social security numbers per second and access to 45,000 students and alumni information. So obviously, unauthorized access, that's pretty clear. We understand he had no right to be on that. But what about exceeding authorized access? In 2004, Mr. Nozzle left executive search firm Korn Ferry International. He persuaded current and former employees of the firm to download confidential information from the company's computers and transfer the information to help him start a competing business. After an investigation, the FBI intercepted email and had him and other employees that assisted him indicted for this. Based on that case, we had another case here in the Northern District of California in 2012. Is everyone familiar with pay-per-click advertising and Google Ads? Well, for those that aren't familiar, pay-per-click means, for example, McDonald's would give Google a deposit account, let's say of $1,000. And they'll work out a fee schedule with them, or a rate schedule, where for 50 cents or $1, every time someone types that in and clicks it, it would come up with McDonald's and it would deplete that account. Well, there was a company and they were trying to sue, InCourt was trying to sue for click fraud. Has anyone heard of click fraud? Click fraud is what they do is, let's say you have a $1,000 account that you replenish every month to run your Google AdWords advertising campaign. Well, your competitors say, hey, I see Chet's campaign, so I don't like Chet competing with me online. I want to get rid of this, and I have a feeling that his budget is not that big. So we're all going to go to Google and keep typing in his name nonstop to deplete his whole account and erase him and erase his advertising before he can replenish it. So that happened to a company, they sued for it. However, the court said that that didn't exceed authorized access because the competitors never had an actual interest in it. So the way we interpret that is an actual interest is someone that obviously works for the company or has some type of financial relationship, whether a consultant or some other concern with the company. But merely asserting a violation of the Computer Fraud and Abuse Act without enough details is insufficient to establish subject matter jurisdiction for the court. Anti-cyber squatting. Is everybody familiar with cyber squatting? People that buy up a bunch of domain names. So the Anti-Cyber Squatting Protection Act allows you to go after someone that registers a domain name just to take financial advantage of someone else's trademark. You can bring a federal cause of action for bad faith registration and use of a trademark as a domain by someone other than the mark's holder. Under certain circumstances, the statute provides trademark holders an interim cause of action against an infringing domain name, and it allows you to get the domain name back. Now, short of going this route in federal court, they do have the Uniform Domain Name Dispute Resolution Program where you can go to the UDRP, file a complaint over your internet issues, domain name issues, and try to resolve it there. However, their decisions are not binding. And so if you do choose to go the UDRP route, which is less expensive than going to federal court, you can still later bring your suit up in federal court so you have a second bite at the apple. Nevertheless, you just be advised that it's not binding. And there is some ambiguity in the law whether or not you have to own the trademark, because sometimes if it's registered, and there's other nuances based on different circuits in the country about what constitutes enough to pursue the action. So here's an example. Let's say, Tiger Woods wants tigerwoods.com, and he's doing very well, and he's established his name, but he never registered tigerwoods.com. So somebody else early on says, hey, this guy's valuable, I think he's gonna be something in the future. Let me register it, and then when he wants it, I'll try to sell it to him for like $1 million or something like that. Well, that's an example of purchasing it for a bad faith intent. The court looks at, did you go ahead and use the website, or you're just holding on to it? Now, be advised, if someone did purchase this tigerwoods.com website and it was not used for a commercial purpose, maybe you just talked about the woods, or you just talked about nature or philanthropy or things of that nature, it's a very low likelihood you could get that domain name back. But if it's for a commercial purpose, it more fits you along the lines of what they're looking to rule out. Typo squatting. Typo squatting is a type of cyber squatting based on an internet user making a typographical error, different phrase domain name. For example, your website is example.com and they come up with examples.com. Or example.org, and they buy different top-level domain names. This is important because people are basically trying to steal your customers and trying to find little unique, sneaky ways to draw attention away from your website. Is everyone familiar with all the new top-level domain names that have come out, like .club, .ceo, .Los Angeles, and .attorney? Many more are rolling out as the years go forward. For example, my domain extension is .technology. But so this could greatly come up if other people are trying to do it just to take your names and to cause confusion. Well, the one case that we're talking about right here is Cyber2 Media. They registered 105 typo squatting domain names, all derivations of Facebook. Facebobk.com, facebookwelcome.com. All told, this happened in April 2013 in Northern District of California. It was brought under the Cyber Squatting Act, and basically the judge recommended a $2.8 million damage award against them for doing this activity. So, you know, it's just crazy the type of things that you see and the type of levels of deviousness, behavior that people go through to make things happen. But at this point, I am open for questions and answers, and I thank you for all your thorough attention during the presentation. And thanks again for coming.